members is not possible, then committee is permitted to or authorized to recommend recovery. Sorry. Well, therefore, the Surface Act, the Recovery and Bankruptcy Act, all of the legislation, IBC code, all meant for recovery is certainly permitted. But these all are central enactments, and the central enactments has to be construed harmoniously. In terms, the MSMED Act is a later enactment, but I am not saying that I am not claiming any right based on the concept that a later law will prevail, that is posterior prior contraria aberrant. In my submission, there is nothing contrary, nothing, there is no, therefore, question of dependency, nothing of the sort. All these legislations coexist, and it is the result of a long-term process of consultation between the Ministry of MSME, Ministry of Finance, MSME Association, and the Bankers Association, and the I gave a long list of correspondence, meeting, everything I produced. I don't have a copy right now. And now that the Parliament in its wisdom, the government in its wisdom felt that MSMEs have to be protected. For it is the backbone of India's economy in terms of employment. It raised 60% employment. In terms of GDP, it raised 34%. And in percent of exports, it is about 50%. Therefore, it is a legislative wisdom, the executive policy that MSMEs shall be protected. They should not allow to die. So it's a preventive legislation to call MSMEs from falling sick. And it is a remedial legislation where it has fallen sick to revive them and bring back to life. And at the same time, the Parliament has in mind the interest of the need to bring the robustness of the financial institution. That is also very much in the mind of the legislature and the government. And therefore, the committee, which has contemplated on the notification, is primarily a committee which has the bank has the primacy in that. The chairman of the committee is a senior officer of the bank, and the second member is a senior officer of the bank, and the third member is an expert on the subject, and the fourth member is a representative from the state government. I am not referring to anything now. In briefest possible way, what exactly is my case. So my contention is this notification creates rights and obligations in addition to what is this is I have a little problem with dryness. Now, my Lord, therefore the notification, I take your lordship to, I won't take time, very briefly, I take your lordship, page 70. That the heading was in exercise of the powers conferred in section 9 of the Micro, etc. Act, the central government notifies the instructions for the framework, etc. I am not reading the entire thing. Then, madam, I take your lordship to section 9. At page 9, section 9, very briefly. Section 9, at page 9. Very briefly, I will only just make a reference to the section, I will not read it. Just section 9. Measures for promotion and development. At page 9. Page 9 or section 9? No, page 9 and section 9. It is the same only. Page 9 and section 9. Measures for promotion and development. The central government may, from time to time, for the purpose of facilitating promotion, etc. I am not reading it to save your lordship's time. Now, my lord, may I take your lordship to section 29 at page 15. Yes. Page 15, section 29. Power to make rules. And subsection 3. Every notification issued under section 9, and every rule made by the central government under this section shall be laid as soon as executed before the fourth house of the parliament. Said, my lord, a common, you will find it in every legislation. So it is, then my lord, it is received the assent of the both the house of the parliament, and therefore, my lord, without any judicial pronouncement, it undoubtedly has, my lord, statutory authority, statutory sanctity. And then, my lord, I take your lordship to the object clause of the act, my lord, at the beginning, object clause of the act. Object clause is, my lord, I believe, Chief Justice Cock only said it is the key to the, my lord, the intention of the legislature. And object clause, my lord. Statements of objects and reasons at the beginning. The small scale industry is at present defined by the notification under section 11B of the Industries Development Regulation Act of 1951. Section 69B of the Act provides for notifying reservations of items for exclusive manufacture in the small scale industry sector. Except for these two provisions, there exists no legal framework for this dynamic and vibrant sector of the country's economy. Many expert groups, etc., I'm skipping my lord, then coming down. The last part, added to this, I'm skipping a few sentences to save time. Added to this, a growing need is being felt to extend the policy support for small enterprises so that to enable them to, so that they are unable to grow into medium ones, adopt better and higher levels of technology, and achieve higher productivity and remain competitive in the fast globalization area. Thus, as in most developed and in many developing countries, it is necessary that in India too, the concerns of the entire small and medium enterprise sector are addressed, and the sector is provided with a single legal framework. As of now, the medium industry or enterprise is not even defined by any law. So the legislator had all in mind here the pre-existing enactments and wanted to support the MSMEs. And bottom down, the power of the central government to notify programs, guidelines, etc. I'm not reading more. Then let's make provisions for ensuring timely and smooth flow of credit to small and medium enterprises, to minimize the incidence of sickness among and enhancing the competitiveness of the enterprise sector. So the legislative intention is to ensure that MSMEs are not allowed to die, and wherever it is possible and feasible for revival, to extend them nursing and care, and that is in the interest of the.
Right, so it's not as a
Yes. And now this I am entitled to the benefit of this notification. Notification casts a responsibility on the principal lender. That is the ICICI Bank. ICICI Bank, may I take your lordship to the page 71. Page 71. Yes. At page 71, para 4A. Application to the committee for a corrective action plan, Form A. The application shall be made to the committee of that bank to which enterprise owes the maximum amount of debt. I'm a environmentally friendly company, but I'm producing solar panels with the import of the technology from America. And I have taken the principal creditor and my banker, my foreign dealer, everything is the ICICI Bank. And for this particular project, I applied for a loan, and the TDB had granted me 7.5 crore as loan. But the ICICI, they granted me 9 crores as loan. And therefore the ICICI was the principal creditor, principal financier. So the committee, in terms of the notification, this was the ICICI to constitute a committee. And to the facts are not very relevant to this case, but measures were taken. In my anxiety to resolve the matter, I paid for 5.4 initially. Then, during the course of the litigation here also, a proposal, at some point of time they were talking to me. I paid another 1 crore. So in the process of the litigation, 6.5 crore has been paid. Now I am forced to litigate because otherwise there is no other option open to me except that. There is no other option open to me. And every moment, many attempts were made for resolution of stress. And their high-handedness alone that prevented any resolution process becoming not feasible at all. Now, this committee, my sole grievance is the ICICI Bank did not constitute the committee, did not make a reference to the committee, and therefore the benefit under the protection which the MSMED Act and the notification control and being granted me, that was denied to me. So therefore, the MSMED Act and the notification which creates certain rights which is in addition to what is recognized by common law and has certain obligations on the bank and financial institutions. In a way, it has certain obligation on me also. And insofar as that notification has not provided any alternative forum for the create any forum for the adjudication of the dispute, the jurisdiction of the civil court is not ousted. And from the day one, I filed a suit, and I filed a suit in the city civil court. The city civil court took the view that the civil court jurisdiction is ousted. That was challenged before this court. This court granted an injunction. Then the injunction was vacated. The matter was relegated to the city civil court, and the city civil court again declined the injunction. Then I referred to the matter straight to the Supreme Court under Article 136 for a resolution, for a final decision on this matter on a pure question of law. And the High Court, the Honorable Supreme Court was pleased to refer the matter to the High Court for adjudication here. I take your lordship to, and I'm not doubling you, let me tell you what my case is. Then the Supreme Court asked the High Court to decide the matter. And before the High Court could decide the matter, then my lord, they invoked the further steps under the Surface Act. And therefore I issued a writ petition. And that writ petition was admitted. Supreme Court page 94. Page 94. Page 94. Page 94 and page 95 below. Page 95. That paragraph. In our view, the lordship quoted below, the parties must be relegated to the Bombay High Court to determine the controversy, whether as referred to as aforesaid or any other petition, please. It will be appropriate to involve the jurisdiction of the. It will not be appropriate to involve the jurisdiction of this court under Article 136 of the Constitution at this stage, as would have the benefit of the law of the High Court on the said matter once this is so raised. In view of the aforesaid, we relegate the petitioners to the jurisdiction of the High Court, where all pleas available to the petitioners can be raised, including the plea as aforesaid. And needless for us to observe that the High Court could deal with the merits of the case. Now, my lord, before the High Court could decide the matter, further steps under the Surface was invoked. Yes, before the High Court, the matter could be decided. Further steps under the Surface as well initiated. Then my lord, we instituted a petition, and many other MSMEs, my lord, type petition was admitted. In fact, even before another petitions, other petitions were admitted, and all those petitions were finally heard on a reserve orders on 9th of August 2024. I take the motion very briefly, just to the date only to the date that at your lordship will find at page 173. Yes. 173, 9th of August 2023. At page 193, date of reservation, 9th of August 2023. Page 173, 173. Now while the repetition is pending, the GDP invoked section 7. GDP invoked section 7. Then we point out to the tribunal that the tribunal has no jurisdiction because ICICI Bank, which is under obligation, according to us, which is under obligation to constitute a committee, without which, if no committee is constituted, the benefit of the MSME Act is out. Then the ICICI Bank is not even a party, and therefore the NCLT is a quorum non-judicial. And we said the issue whether I'm entitled to benefit of notification, etc., is a matter which is pending before the High Court, and so adjournment of the matter, nothing else. And the judgment which was reserved on 9th of August 2023, the judgment came to pronounce almost 6 months later on 11th of January 2024. And on the judgment, this court took the view that notification is not mandated, and therefore the benefit of the notification cannot be extended to, or can only be extended to those who apply for it, and there is no statutory obligation. That is the finding. I take your lordship to the finding part of it is. Now, my lord, I challenge that order in the Supreme Court under Article 136. That came to be dismissed on 29th of January 2024 at page 200. My SFP came to be dismissed. Then, my lord, I filed a review petition. And my review petition, I filed a review petition on the premise that the doctrine of neither restituicata nor merger can have no application. For the doctrine of merger to, my lord, apply to be applicable, the court should have found that the cause of action is in existence, and if the cause of action is not found in existence, there is nothing is merging, only restituicata. So, neither restituicata nor merger. The restituicata can apply only if the Supreme Court has an appellate court and my lord adjudicate on the facts and come to a decision one way or other. Therefore, doctrine of restituicata does not apply. Doctrine of merger, that also didn't apply there because merger assumes that there was a adjudication. The NCLT, I am coming to them. Give me 1 second, I am coming to them. Therefore, my lord, I filed a review, and the review was rejected. I filed an SLP against that review, and the Supreme Court allowed the review, which your lordship will find at page 215. That order is dated 8th of July 2024. Your lordship will find the page 219 is the
215.
215 is the beginning, end is 219. I read from page 218, paragraph 15. For the reasons aforesaid, the appeal is allowed in part to the extent that the impugned judgment dated 19/3/2024 is set aside, and the matter is remitted to the High Court with the request of division bench to hear and decide the review petition on merits and in accordance with law. Thereafter, while the review petition was pending, by order dated 1st of August 2024, the original order was set aside by the Supreme Court. Your lordship will find at page 235. 235.
आपल्याला हायकोर्ट मधून कळालं की आता सेशन कोर्टाला
This is known as Brownie's case. And the Supreme Court held this notification is mandatory, it is binding. May I take your lordship to page 251. 251 paragraph 18. In that view of the matter, we are of the opinion that, what is the law? We are of the opinion that the findings recorded by the High Court in the impugned order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in the notification dated 29/5/2015 as revised from time to time could not be said to be mandatory in nature, are highly erroneous and cannot be countenanced. The instructions/directions issued by the central government under Section 9 of the MSME Act and by the RBI under Section 21 and 35 of the Banking Regulation Act, which is also that, have a statutory force and are binding to all banking companies. Therefore, my lord, the position which I canvass, I'm entitled to the protection of the MSME has been reaffirmed. But before that, my lord, on 15th of July, at page 232, this is the, my lord, the mistake that happened at page 232, yes. 222, starting 222, page 222. The NCLT passed an ex-parte order. Ex-parte order allowing the Section 7 application of the TDP and initiating the corporate insolvency resolution process. This is an ex-parte order, and my lord, the most unfortunate, the unkindest cut of all is that on 15th of July 2024, when the order came to be pronounced, I personally went there to NCLT and requested the tribunal that the Supreme Court has allowed my SLP on 8th of July 2023, right? 8th of July 2024. The copy of the judgment has not been updated. Therefore, the tribunal shall wait for the order of the Supreme Court to be applauded, and that be when unheeded. And an order, as parte order, has been passed. And yes, I take your lordship from the order itself. Their status is an as parte order at paragraph 13. At paragraph 13. On 12/3/2024, at page 227. On 12/3/2024, an adjournment was again sought on the ground of illness of arguing counsel. On 18/3/2024, one advocate representing the corporate debtor repeated the same submission and sought an adjournment. Overlooking the past conduct of the learned counsel and the fact that there was no stay in the proceedings, and moreover the provisions advanced by the learned counsel for the corporate debtor, the MSME Act overrides IBC, had you fully been decided by the Supreme Court. This bench arrived at the conclusion that corporate debtor is deliberately dragging the issue, and therefore the bench proceeded to hear the learned counsel or the petitioner and reserve the matter for order. The matter was never argued. When an adjournment was sought, it was said we are making a claim of the MSME Act, and the issue was raised before the High Court. The plea was dismissed, SLP was filed, dismissed, against which the plea was filed, dismissed, against which a fresh SLP was filed, and then on the day when the order was pronounced, we told the tribunal that SLP has been allowed. My contention that I'm entitled to the protection of the MSME Act is upheld, and therefore the tribunal shall not pass an as parte order here. And since then, my lord, we refuse to, my lord, go to the NCLT. The reason is, my lord, The right or wrong, my convention is NCLT is a forum non-juris. The fundamental principle that both parties to litigation has a right to initiate an action or a claim against each other. So, my lord, actio communitarius and actio commodans, if the creditor has a right of an action against me, I have also a right of action against the creditor. So both parties have a right to proceed against each other. I have a right to plead and be either established or plead and be lost, and it may not even penalized with the cost. But the forum, there should be, I'm entitled to a forum. If we just agree the medium, I'm entitled to a forum. And the IBC code is a one-sided forum where there is no provision for where I put even an actor. Actor comes from the minority consent, come from the from the common law. Namo dapat essay exit sorry. Namo partners essay simple actor juris. Namo partners essay simple actor and juris. I'm seeking quashing of the entire declaration that the NCLT has no jurisdiction, a writ in the nature of mandamus or a writ in the nature of sexual-unified mandamus. Quashing and setting aside the entire proceedings initiated against me under the Subversive IPC code and directing bank to constitute a committee, make an refer for resolution of stress. And my lord, similar policy has been accepted by the Kerala High Court after it being dismissed many times. No, my lord, the matter was before Justice Jagla, His Lordship, they took a convention that we have filed a bit before the NCLT. And the court suggested that we clearly provided we withdraw the SLP. Sorry, appeal. We withdrew the appeal. And then, my lord, there I believe the court took the right step. Because here your lordship I have produced a chart. Anybody who sees the chart will accuse Nirambana. He has gone to 56 or 70 proceedings in innumerable forum. I always stand, I assert that there shall be only one forum. Like I said that there shall be only one class of lawyers. There shall be only one forum. And that is one of the agendas of the National Lawyers Campaign. Restore the pristine glory of the civil court. Order 1, Rule 1, CPC. All causes, all parties, all controversies brought before one forum. And this decision, right or wrong, is reciprocate and binding. That is, and therefore we stand by it. Nobody can accuse us for we have produced entire list of the forum. All this forum we have to travel at the enormous cost and at the inconvenience to all, to them also, because this single plea that I am entitled to the protection of the notification was not decided one way or another. Yes. No, my lord, they have issued a notice to take possession. That's the reason why I am troubling your lordship. That date was fixed on last Friday. That Friday, no fresh date has not been fixed. This is the notice. That is the only reason, my lord, we are troubling your lordship. And if there is absolution even possible, settled matter can be settled in a small company. ICICI now only 1.5 crore is due. 1.6 crore is due. And the TDB Yeah, yeah. ICICI Bank principal amount is 1.6 crore. And how much you paid on it? 7 crore. 7 crore has been paid. Principal of 7 crore has been paid. 1.6 crore is due. And TDP, they only released half of the amount. They violated the contract. Only 4.5 they released for the technological development program. 4.5. 4.5. 4.5. No, she paid. No, no. Property paid 9 crore. GDP she didn't pay, but the ICICI Bank paid 7 crore was paid to the ICICI Bank. Yes. Yes, yes. 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 And they don't. Yes. 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 Yes, exactly, exactly. Yes, exactly, exactly. And Malad, now I give one example, Malad. In Kerala High Court, because earlier initially all claim based on MSME notification came to be dismissed after dismissed after. So then the Kerala High Court, with a recent judgment of the Kerala High Court, Kerala High Court noticed that all those petitions were dismissed, but allowed the petition and directed a committee to be constituted. And may I take your motion to page 27? And the Madurai bench of the Madras High Court, yeah, the at page 27, para 31. Page para 31, page 27. The objection is Lordship of please. Page 27, para 31. Lordship. The Lordship of para 31. The objection raised by the respondent bank that the writ petition is barred by recidicator due to the filing of the earlier writ petitions numbers dash 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 etc. and the subsequent proceedings in RP number etc. etc. and writ appeal numbers dash 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 etc. Also cannot be sustained in writ petition number etc. The last series of petitions this court has explicitly left all conventions of the petition is open. Then this paragraph, for the foregoing reasons, it is declared that the first and second petitioners are entitled to benefit of the Exhibit P3 and P4 notification. Exhibit P3 is the notification dated 29 by 2015, and Exhibit P9 and P16 are quashed. Consequently, there will be a direction to the respondents to comply with the Exhibit P3 and P4 notifications, as well as the first and second petitioners are concerned. And only after the said compliance and based on the decision thereon, the bank shall decide on the classification of the accounts of the first and second petitioners as non-performing assets. So, yes. asking to understand
If I can clarify, pursuant to the 15 July 2024 order passed by Honorable NCLT admitting the company to insolvency, while an friend came before the Honorable Bombay High Court. The matter was before Justice Sriram, thereafter the matter went to Justice Gadkari. Justice Gadkari passed a consent order, wherein it was decided that the Honorable NCLT will reconsider the issue of pro-rate judgment and the MSME issue. That order is dated 29th October 2024. That pro-rate has been considered by Honorable NCLT. Yes, my lord. In his writ petition at page number, my lord. October 275. Page number 275 of the writ petition. My learned friend in the initials told that he was not heard on 15 July. Considering all these aspects, Justice Gadkari passed a consent order remanding the matter back to NCLT to consider all these aspects. 275, yes, my lord. And next page, 29th October, my lordship can see. Order dated 29th October 2024. The first para. This matter arises out of the order dated 1st October 2024 passed by Honorable Bombay High Court in writ petition number so and so, the relevant part of which is reproduced. During the course of the argument, both parties agreed that the proper recourse for effective and expeditious determination of the issue in question was to request the NCLT to grant an opportunity to the petitioner to be heard on company petition number so and so filed by TDB against the company of the petitioner. Admittedly, most of the order passed by this court and the NCLT moved by including the order dated 15 July, a state hearing and especially order admitting the company petition filed by the financial creditor, that is some of the respondents hearing against the petitioner prior to judgment, and order of dated 1st August 2024 passed in the pro name. Yes, fine, take my notes. Para 4. Yes, sir. Yes, sir. Eight, para 8. Page number 284. The present matter arose from the order dated 1st August 2024 passed by Honorable Supreme Court in case of Pro Lit Supra interpreting that notification dated 29 May 2015 as a statutory force and fine. Yes. In this case, an insolvent. That also has taken place. Thereafter, another writ petition, wherein Justice Muge has passed an order at page number 262. 262. Well, in the reply of ICICI, does my lordship have the reply of the ICICI Bank? No, ma'am, in the reply of the ICICI Bank, I am referring to the reply of the ICICI Bank. My lordship have the writ petition, I believe, in the reply. Does my lordship have the reply? I've carried the judgment separately. It is part of the reply filed by ICICI.
No. Petition is of 370 pages. Obviously. There is an order.
या बटाटा वाला ICICI Bank. The reply of the ICICI Bank, the judgment has been annexed. I have tendered the copy separately for convenience, my lordship, just to save time. So this is the judgment of Justice Muge, passed on 20th December 2024. Yes, sir. Analysis and conclusion, page number 29. Para 30. It is mentioned that Mr. Nidupara has put forth his heavy submission only against the order dated 15 July 20.29 October 24. The other players canvass to restrain and prohibit the 2 learned members also from functioning. However, there is no prayer for issuance of writ of no warrant for either in the main prayer or in the executive. The further relief sought is to direct the Bank of India to allow the petitioner to operate various lines maintained by the company so and so. Thereafter, my lordship, in para 31, the reference of Justice Gatkari's order is given. Thereafter, pursuant to that order, at para 33, the Honorable NCLT reheard the matter that reference is given. At para 34, the view, if I can read, the view taken by the Honorable Supreme Court is now crystallized that even the non-payment of the part of the debt when it becomes due and payable, para 34, will amount to default on the part of the corporate debtor. In such a case, an order of petition under Section 7 of IBC must follow. If the NCLT notices that there is a debt but it has not been become due and payable, the application under Section 7 can be rejected. Where there is non-payment of debt under Section 312 of the Code, when whole or any part of the installment of the amount of debt has become due and payable and is not paid by the debtor or corporate debtor, as the case may be, it would amount to default and proceeding under Section 7 of IBC must follow. In view, we do not find to consider it illegally 29th October. Thereafter, my lordship, the issue of forum shopping has been dealt with. I'm not on that one. But issue is that now that the insolvency and bankruptcy code also is a resolution process. Under what my learned friend is recommending is also a resolution process. And under the insolvency and bankruptcy code is also a resolution process. In fact, my learned friend's client has also approached to submit a plan for resolution. She had submitted an interest. When the public announcement was made to invite resolution plans from the prospective resolution applicants, the EOI interest was submitted by the petitioner hearing. In fact, extension was also given, considering that this is an MSME and promoter wants to bid for the company. We granted an extension also. In spite of that, no plan was given. Thereafter, when the matter was before Justice Gatkari under review, Justice Gatkari even granted time to show the color of money and we grant review. Till date, then the mechanism is not there. Today, what is happening that I have 11 resolution plans in hand, which I have to approve within a timeline period. Now, due to these proceedings and stay behind the back, what is happening that I am the resolution professional. I am for the resolution professional. So today, what is happening that the prospective resolution applicant out of 11, 5 has already gone, shown non-interest because of the delay, consistent delay. Now, I am under pressure from the Honorable NCLT to complete the process in a time-bound manner. Today, till date, I am duty bound to take possession of the property of the company. They have been showing consistent resistance to take possession. By some or the other means, they have been filing frivolous petitions before my lordship and taking states
Like apart from this, any other thing you can
I don't, in my knowledge, where I'm partying and there, yeah.
any other
There is an appeal pending, because the suit filed by our vendors in this court of case. Against that, there is a commercial appeal which is pending that. But as per my knowledge, any other
My lord, with all due respect, I'm under an order of honorable NCLT to conduct the proceedings. And what I'm saying, if my lordship are inclined on directing me, it's better that my lordship may grant a stay. Because I cannot give a statement today. I'm in a difficult circumstance. About
the finance subcommittee, I'm from the accident and the entire argument which is made by my lawyer friend is with respect to the NSA. Now that notification per se is applicable only to banks, which scheduled banks, non-scheduled banks, cooperative banks, or private banks. But that notification is applicable only to the banks. The respondent number 1 here is a technology development board understanding. So the DDB is a board, it is not a bank. The financial facility which is granted by DDB is separate than the financial facility which is granted by HDFC.
That you are the compilation of all this.
we will prepare short.
That's very good. If I are not there, then go ahead. But this is the bigger point that I want to say. We always create any right of interest. So whether it was right and to that extent, whether there is this possibility, the answer to all these questions are negative to and the answer is positive, then we should clear one question. That the government has not implied anything that is no. That also presents what we can. Obviously, we are extending that. First, and this game,
Yes, madam. Since your lordship asked me to sit, I will.
you have to conclude this order.
All right.
No adjournment.
Yes, when your lordship is pleased to keep on, then this is.
After the this is 11 o'clock.
We will carry the brief.
20th, Saturday 20th.
So that you can do more than you have to pull out some computers. These were you have seen there were few orders
But last 3 years.
Yes, unstable. They also identify. But
Yes, yes. 20th. 11th. Whatever issues are there, I said, whatever inconvenience is there, I'll come. I'll be here.
we are seriously trying.
Yes. I have some programs on, but that I will avoid slightly.
This is also a problem.
Well, tomorrow I am traveling to Cochin.
Right. We will do that. Okay, that's.
All of you will get to what
appearance loss. Right.
Yes, no, no, very brief.